Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Thursday. Y'all, I've just been taking a little time for myself, and it's been nice. 2 weeks, I was traveling pretty nonstop, and it caught up with me going in 2 different time zones, coming back home, staying busy. It's all good, though. I love what I do. Taking my daughter to see Inside Out 2 later today, so I'm knocking this out early. Hope you're having a good day wherever you are in this big world. We're going to get started, but first, if you're watching on YouTube, you know the drill. Don't forget to hit subscribe if you haven't already. Like the video, share it with your friends, and you can ring my bell if you want notifications of when I post new content. Just click that little bell icon. Music fact of the day. The song Ants Marching by the Dave Matthews Band describes how we get up and do the same routines and the same things every day without meaning or emotion. And we are just ants following our leader, not really knowing why. I have to give a shout out to an alibi for this really cool shirt that I got at CrimeCon. I love it. It's from the Church Studio. Very interesting story. Google it if you want to find out more. You guys were so amazing to me. I appreciate all y'all. This is probably going to be 2 separate episodes. The filing is very large, but I did cover this trial daily for George Wagner, so I want to dive into why he says he's entitled to a new trial. It would just take a couple of hours if I did the whole thing right now. I'm going to leave some things out, but just hit the main parts. Tomorrow, I'm hoping to get in the Brian Laundrie FBI file episode. The problem is that some of the scans of the letters that Brian wrote that are in the file are so hard to read. I'm trying to tweak those to see if I can get some more words to pop up, but so far, no luck. We may just have to read what we can. But for today, just a reminder, he was convicted in the murders of 7 Roden family members and also Hannah Hazel Gilley. He was sentenced to 8 life sentences and 121 years on other charges. And now he wants a new trial. In the beginning of the filing, they bring up the concerns that Jake Wagner had over Sophia, a child he shared with one of the victims, Hannah Mae Roden, where he was very paranoid. She may be touched inappropriately while in Hannah's care. And that's ultimately what led to these murders. They run through how Angela suggested they turn Chris Sr. in for his marijuana grow operation, but Billy didn't want to do that. Billy initially wanted to kill Hannah Mae, her dad, and Hannah Mae's brothers, Frankie and little Chris. When Angela asked why it just can't be Hannah Mae, Billy said they would know it was Jake and they would come for him. When they told Jake their plan, he initially said no because he said he still loved Hannah Mae. And when, according to Jake, he asked Hannah Mae what would happen if something happened to their daughter like it did to Hannah Mae said, according to Jake, I guess we'll just have to deal with it. And that was Jake's tipping point, apparently. The filing says that Billy took the primary role in planning the murders. Jake agreed to obtain a vehicle that was not theirs to avoid suspicion, as well as prep firearms with silencers. Angela acquired a list of stuff that they would need to evade detection and also prevent any calls to 911, including a bug detector, a cell phone jammer, and shoes. It says Billy wanted smaller shoe sizes than what they normally wore. They go through what Angela bought, the shoes at Walmart, forging those custody documents and things she bought online. And then they summarize the crime scenes with Billy shot Chris Sr. and Gary at scene 1. Jake killed Frankie and Hannah Hazel Gilley at scene 2. They also mentioned that Billy shot Frankie a couple of times after he was deceased. Jake killed Dana, Hannah Mae, and little Chris at scene 3, and Billy killed Kenneth at scene 4. They say Jake attempted to destroy and hide the remaining evidence and claimed without any direct corroboration that George assisted. They mentioned in a police interview that Billy said he broke his phone because after hearing about the murders, Chris Sr. would not pick up his phone. Investigators knew, though, the last outgoing call was from Chris Sr. to Billy from Chris Sr.'s phone, and those calls were never returned by Billy. Jake goes on to enter a guilty plea and leads the state to the murder weapons and the truck used in the murders. Angela followed suit, pled guilty. Both of them testified against George at his trial. The agreement Jake made with the state was that if he testified to their liking, they would remove the death penalty for for the rest of the family members when their trials came. Let's jump into the argument. The trial court erred and denied George the right to due process by rejecting requests to dismiss the capital specifications against him before trial. George was entitled to, without the specter of the death penalty hanging over him, his brother entered into a guilty plea requiring the dismissal of all death specifications in the case without delay. Waiting until after the close of evidence to dismiss them was not justified. The court should reverse and remand for new proceedings without all the trappings of a death penalty case, as George requested before, during, and after trial. Before this court reaches the constitutional question, it should consider whether George was entitled to have the death specification dismissed from his indictment long before trial under basic contract principles. After all, plea deals like the ones entered by Jake and Angela are contracts between the state and criminal defendants and are subject to contract law principles. The state agreed with Jake that in consideration of his agreement to provide truthful testimony in the trials of each of his co-defendants, specifically including George, it would dismiss the death penalty specifications in counts 1 through 8 of their indictments. If Jake did not comply with his agreement, the state was authorized to reinstate the original charges with all of the original specifications against them. When the trial court accepted this agreement and journalized Jake's guilty pleas, it was further ordered, upon acceptance of the defendant's plea of guilty to the above outlined offenses and specifications, the state moves to dismiss specifications 4, 5, and 6 from counts 1 through 8, respectively. This entry incorporated the earlier agreement, and it again reflected that the state agreed to dismiss the death specifications against George. While the state steadfastly opposed the dismissal of death specification until the very end of trial, that is not what Jake's plea agreement provided for. The agreement to dismiss the death penalty specifications was to be performed immediately upon acceptance by the trial court, which is why Jake's own specifications were dismissed right away. There's no text in the plea agreement or entry contemplating that George would not also be relieved of the potential penalty of death right away or sometime later for performance. Indeed, the state agreed to dismiss the death penalty for Jake's co-defendants in return for his agreement to provide truthful testimony, not after the delivery of the testimony. Further bolstering this meaning, there is no purpose for a term permitting reinstatement of death specifications against George if Jake were to later breach the plea deal unless the parties contemplated immediate performance. Even if the clear text did not say that George's death specifications should have been dismissed after Jake's plea was accepted, the law implies that performance is to take place within a reasonable time in the absence of a provision specifying the time. George should not have waited for far more than a year from April 22nd, 2021, the acceptance of Jake's plea, until the November 22nd, 2022 dismissal. That was unreasonable. The state confirmed with Jake that he entered the plea deal because he wanted his family members, quote, to be able to go to trial without the fear of death, end quote. Well, they sure didn't afford their victims the same, did they? George is named a third-party beneficiary of Jake's plea deal, and it was explicitly entered with the intent to benefit him. Since George cannot very well elect to withdraw Jake's plea to rescind the deal, the only appropriate remedy is specific enforcement. The court should reverse and remand with instructions to hold a new trial proceeding without any pending death specifications. Another argument, forcing George to trial before a death-qualified jury was fundamentally unfair in light of the reasonable expectation that death specifications would be dismissed. Alternatively, the Due Process Clause of the 14th Amendment to the United States Constitution and Article 1, Section 16 of the Ohio Constitution required pretrial dismissal of the death penalty, given that nobody reasonably anticipated a death-qualified jury would be necessary. In each jury selection, the state opposed George's request for additional strikes on account of the death specifications against him. It had already admitted the significant chance that we would not make it to a mitigation phase as far as procedurally, given the path this case has taken. Precisely because a full capital proceeding was unnecessary in light of Jake's plea deal, it should not have been allowed as a matter of procedural due process. The court has expressed that procedural due process is not a technical concept, but rather concerns fundamental fairness. What process is due depends on considerations of fundamental fairness in a particular situation. It is an apparent question of the first impression whether the state can pursue death penalty specifications through the close of evidence in a trial when it knows it will be required to dismiss them under a plea deal before jurors deliberate. So at first, it makes sense to express that this procedure was fundamentally unfair on its face without getting into the balancing factors. A death penalty trial unlocks the enormous power of the state to bear down on a criminal defendant with every resource available. The process of qualifying jurors to sit on a death penalty case placed George at an immediate disadvantage, as death qualified juries are more likely to convict than juries that include those who would not return such a verdict. Another argument is that 4 jurors that could have served were excluded partly because of their views on the death penalty. This had a real impact upon the jury pool, as any of these jurors could have been selected if they had remained in it instead of some other person who did end up serving on the jury. The 3-factor test under Matthews confirms that due process required dismissal of the death specifications against George before trial proceedings began. His protected interests were liberty and life, at least during jury selection and trial before the state complied with its plea deal. They called down the greatest protections due process can provide. The risk of deprivation of his liberty was greatly heightened, given the increased likelihood that a death-qualified jury would convict him, a concern that would have been removed by holding a normal trial. And removing the death penalty would have relieved fiscal and administrative burdens from the state, as it would not have had to summon hundreds of jurors and tried the case for months. Dragging George through the process needlessly violated his state and federal due process rights. The court should reverse and remand for a new trial without any pending death penalty specifications. Another argument they have, the trial court erred and abused its discretion by failing to strike several jurors for cause. At least 3 of the impaneled jurors should have been excluded for cause given their familiarity with the victims of April 22nd, 2016. That's the date of the murders, by the way, and the answers they gave, but they were impaneled nonetheless. This court should reverse and remand for a new trial before a fair jury. Standard of review for juror challenges for cause. The right of trial by jury, guaranteed by the Constitution, carries with it, by necessary implication, the right that the jury be composed of unbiased and unprejudiced persons. It is proper to exclude a potential juror who has expressed uncertainty as to whether she would be able to fairly and impartially determine the facts, or who has a generalized bias and an unwillingness to set that bias aside. The trial court should excuse a challenged juror if the court has any doubt as to the jurors being entirely unbiased. They talk about jurors who knew the victims. A juror knew Chris Sr. and Dana before they were killed. He expanded on whether it would impact his jury deliberations. In addition to being in favor of the death penalty in every case where a murder has been committed, he attended school with Chris Sr. and Dana and went to church with Dana growing up. He would speak to them if he saw them around, and when asked whether he could presume that George was not guilty of their murders, he answered that he would like to think so, yes. The state asked if he could decide solely on the testimony and evidence, and this gentleman answered, "I would like to say yes, but there again, you got your opinion." When asked to confirm that his already held opinions would persist, he answered, right, absolutely, absolutely. He could not answer in advance whether seeing Chris Sr. and Dana dead in photographs would have an undue impact. He said, "I would like to think it wouldn't affect my judgment, but I actually seen it, you know?" He could not answer a hypothetical question. With another chance to question this juror, the state got him to agree he could not find George guilty based solely upon gruesome pictures of Chris Sr. and Dana if he otherwise thought the state hadn't proved his case. But he did not deny the shock of such photos would weigh in his analysis. The trial court abused its discretion by overruling George's request to excuse this juror for a number of reasons, including because he knows 2 of the victims, the strong views on the death penalty that he expressed in court, and on his long-form questionnaire, and his hesitance to give the presumption of innocence. I was really shocked they kept this case in Pike County, to be honest with you. It's just so small. In the questionnaire, the juror answering that criminal defendants should testify, offering the most extreme views in favor of the death penalty available on the questionnaire, and denying he would consider or respect the views of other jurors on the death penalty. There was no way to remove all doubt about his capacity to be fair given his answers. George was correct. This gentleman tried to please the person who's asking him the question, and his first answer was more of an indication of his attitude than anything else, along with the answers on the questionnaire. The inflammatory nature of gruesome photographs can create a danger of prejudicial impact on the jury's deliberation. The jury did not confirm that he would be able to consider violent pictures of victims he knew from childhood without allowing emotion to impact his conclusions, and he denied he was even able to answer a hypothetical along those lines. He should have been excluded. Another juror knew Hannah Mae, Frankie, and little Chris from her time working at their school, and she admitted that photos of their death could sway her. She knew Hannah Mae from her time working at a school as an interpreter for another child in the same set of classes. She saw Hannah Mae pretty much daily and also had been a substitute teacher for Frankie and little Chris. More recently, this juror had attended a fundraiser collecting money for the funerals. She denied that she could answer how she would react to gruesome photos, saying, "I cannot tell you how I'm going to react when I see the pictures. I don't have any idea what I'm going to do. I don't know if I'm going to cry." She volunteered that she was a sensitive person when asked if violent photographs of the children she met at school would affect her during deliberations. She said, "I wouldn't be human if I didn't act that way." When George asked whether she would be more sensitive about seeing photos of children that she knew, she also denied she could answer that before seeing the photos. When she was certain of things, she gave definite answers. For example, she was familiar with the Pike County prosecutor who had handled a case in which she and her husband were the victims. She gave a clear yes. She could put that positive experience aside and judge this case fairly on the merits of the case. George asked to excuse the juror for cause because of her answers about the photographs of the children that she's familiar with from school. The answer we needed to hear was no, it would not have an effect. I'm concerned that it is possible that it could have an effect. She had the opportunity to say no, it wouldn't, but she said possibly. For the same reasons the previous juror should have been excused, the trial court abused its discretion by denying the for-cause challenge to this juror. She did not answer definitely that she would be able to set aside any emotional response to the photographs of the violently murdered individuals who she had known as young school children, and render a verdict dispassionately, leaving substantial doubt about her capacity to serve fairly as a juror. Another juror worked as a dispatcher for the ambulance company that received the initial emergency call on the day of the murders, April 22nd, 2016. And she spent that day arranging the transport of the victims' infant children. The juror worked as an ambulance dispatcher, and she had worked on the response to the killings as the authorities discovered them on April 22nd, 2016. They referred to the questionnaire where she said the whole case was very close to home for her. She even got the original call to send out an ambulance. She lived that day hearing there was a lot of blood and trying to get the kids out of the scenes and go to a hospital. George asked the trial court to excuse for cause because of her personal involvement in the case. There were plenty of jurors available who don't have intimate knowledge and emotional connection that she has to dispatching units to the crime scenes and had not heard information from people that were at crime scenes. The trial court abused its discretion in denying this for-cause challenge given the significant emphasis during jury selection on the gruesome photos that would be shown during trial. The risk of a prejudicial emotional response to the evidence at trial was too high for the court to accept her promise to disregard what she already knew. She had followed the movements of the infants found in bed with their dead parents all day on April 22nd, 2016. The next argument, the trial court erred, committing plain error, and abused its discretion by admitting gruesome photographs and victim impact testimony for days on end. After choosing a jury partially made up of individuals who had known some of the victims personally or heard about the emergency response, the state's strategy played directly to their closeness to the case. Not only did the jury see a great volume of gruesome photographs from the crime scenes and autopsies over the first 2 weeks of testimony, they heard directly from surviving victims about their emotional reaction and the moral impact the murders made on their lives. Each step along the way, other less prejudicial evidence would have served fine as an alternative. And in any case, George did not dispute any of the facts about the crime scenes or the emergency response on April 22nd, 2016. George deserves a trial without such a shocking and emotional presentation, which likely played a significant role in the jury's deliberations. Even if relevant, a court must still assess whether the probative value of evidence is substantially outweighed by the danger of unfair prejudice, of confusion of the issue, or of misleading the jury. The state built the structure of its case around the most gruesome evidence. George consistently opposed the state's effort to present enormous volumes of gruesome photographic and physical evidence showing the victims as they were found dead and during their autopsies. The trial court admitted numerous duplicate, bloody photos of the victims shown at the 4 crime scenes over George's objection. Jurors were also provided with duplicate and often close up photographs from each victim's autopsy, which were spine chilling. They also mentioned clothing worn by the victims, bloody bedding, and each of the bloody diapers worn by the children at the crime scene were admitted. The problematically gruesome evidence is too large to analyze each objectionable exhibit in detail, and a few examples are therefore warranted to demonstrate how the trial court abused its discretion as to each of them. For one example, the state explained that it wanted to show jurors the blood patterns left in little Chris's bed after his body was removed. Not a single witness had testified about the pattern of blood left in his bed or explained what meaning could be gleaned from it. Like all of the other unnecessarily violent and visceral evidence admitted over objection, there were no meaningful disputes about any facts that it could prove. Either George was not disputing who was in the bed, whose blood it was, anything like that. The only apparent purpose was to inflame the emotions of the jury. This echoes George's numerous objections throughout the trial that he was not disputing any facts about the crime scenes, the forensic evidence found there, or the manner and cause of any deaths, none of which connected him to any crime independently of the testimony of Jake and Angela. Ultimately, the blood and gore were the point of the first 2 weeks of the state's case in chief. Another example showing that to be true are the photographs that were taken of the bloody baby, which was shown during trial and admitted over objection. On the first day of trial, jurors saw disturbing pictures of the blood that was still covering the child upon arrival to the hospital. The state then led its crime scene investigator to identify a single droplet of blood in 2 photographs of the hallway at scene 2. By the way, that would have been Frankie and Hannah Hazel Gilly, which would be consistent with blood falling from the child as they carried it out. None of this evidence was probative of anything that mattered at trial. Proving that to be true, the state only had one witness who was familiar with the events at the scene of the murders, Jake. When he testified, the state only showed him a few photos from each scene and none of the especially gruesome ones. They also say that the coroner had diagrams showing the injuries to the victims and was able to give all relevant information on cross using just that. The trial court abused its discretion by permitting the state to overload the jurors, some of whom knew the victims, with bloody and violent pictures of their deaths and autopsies and related blood-soaked items, particularly during the first weeks of the trial. The probative value of the photographs admitted over objection did not outweigh their prejudicial impact. Quite the opposite. Unfair prejudice was the point, and George needs a new trial as a remedy. The state relied upon and focused on significant victim impact evidence. The other prominent category of unduly prejudicial evidence admitted at trial was testimony showing the impact the killings had on the victims' family members. It's only admissible during the sentencing phase of the death penalty proceedings or if relevant to the facts attendant to the offense. Such evidence tends to inflame the passions of the jury and risk conviction on facts unrelated to actual guilt. And this court has generally reviewed whether testimony was so emotional that it affected the outcome of the case. The state put on a remarkably emotional presentation for the jury, which was neither necessary nor probative in light of the other evidence available. Prominently, the state offered a dispassionate testimony about each crime scene from consummately professional law enforcement officers and first responders who described each location in detail as it was on April 22nd, 2016 and immediately thereafter. There was no reason for the state to put witnesses related to the victims on the stand to testify about discovering the murders. Yet, that is exactly what the state did, leading the trial court to point out we don't see a lot of cases where this many family members are anticipated as witnesses other than in domestic cases. Dana's sister, Bobby Jo Manley, had found Chris Sr. and Gary inside scene one, and she was so upset after she exited she needed her friend to physically hold her. In the middle of proper testimony offered by paramedic Daryl Hart, who had also known Dana, the state for some reason started asking him about what kind of person she had been. Quote, "Oh, she's a hardworking individual," end quote. Leading Kenneth's cousin Donald Stone, the state elicited that the Roden family were close-knit, helpful people who would look out for one another. This drew an emotional response from Mr. Stone, who had to be asked, "Do you need a minute to collect yourself, or are you okay to go forward?" Outside the presence of jurors, Georgia's counsel noted of Mr. Stone, and then they pull from the transcript here. Georgia's defense attorney says, "Judge, I just want to put on the record that the last witness was crying and very emotional while identifying the photographs of the victims, even though we offered to stipulate them." The court said, "I think he was crying before he even identified photographs." Georgia's defense attorney, Mr. Parker, said, "But especially so when he saw the photographs." And the court, "Well, I don't necessarily find it especially so." Whether or not it was caused by images of Kenneth dead, he cried for the jury. Kenneth's son, Luke, was asked to agree that this victim was involved in his children's lives, supportive of their endeavors, and even recently helpful in paying for Luke's tuition to trucking school. Kenneth cut Luke a check that day that he was killed. Luke said he would routinely help people out. Luke and the friends who went with him to find his father's body on April 22nd were understandably in shock and very emotional and angry. Kenneth's daughter, Kendra Roden, told how Kenneth was also trying to support her through a nursing career so she wouldn't have to take out loans. Kendra offered that she had driven over to scene one after hearing the news, where she found out Hannah Mae had also been killed, cried, and tried to push past the sheriffs there. Later, Kendra found out her father had been killed and dropped to the ground crying. During the third week of trial and after the relevant evidence relating to the crime scenes had been covered exhaustively, Dana's sister-in-law, April Manley, got on the stand for the apparent purpose of describing how heartbreaking April 22nd, 2016 had been for her family. April described the various family connections and explained that her husband, James Manley, and Dana had an unbreakable bond. James was an emotional wreck after finding Dana dead and hearing Hannah Mae's baby crying. When he heard the baby crying, he said he wouldn't walk back there. He knew what kind of mom Hannah was, and she wouldn't allow her child to cry like that. When the baby was brought out of Dana's house, April asked to hold the child for a moment, but the EMT denied that request until any evidence could be collected. April went along in the ambulance, and she was only permitted to hold the baby for a brief period, and she was eventually asked to leave. Jake had appeared in the parking lot by then. He was emotionless, according to the witness. The state's final question for her, and can you tell us, did you also share with BCI why it bothers you so much that Jake hugged you that day? Her answer, because I often wonder if he still had my baby's blood on him when he touched me. So that's part one of this. It's lengthy. I get the arguments, but these photographs are the reality of what happened to the charges that he's charged with. And you hear this argument a lot in court. They don't want these crime scene photos and the reality of the brutality of these murders coming in for the jury to see. That's the defense attorney's job. At the same time, it's a little bit harder because you do have a family member that discovered the bodies initially. She was working at Chris Sr.'s house in the mornings, and you have to remember Bobby Jo Manley not only discovered Chris Sr. and Gary first thing in the morning when she went to Chris Sr.'s to do work she had been doing over there. After discovering their bodies, She ran a short distance over to Frankie and Hannah Hazel's trailer and found them dead. I mean, this is somebody who discovered 4 bodies of her family members in the morning. I don't know how you don't include her testimony. She's the first one there. Also, in the beginning, there was suspicion on her that maybe she did this. It's been a mess. And I mean, 2016, you're looking at 8 years since these murders, and you have 8 victims. It is an enormous amount of victims. This may be one of the most brazen murder cases I've ever covered or ever will. It is just, you're talking 8 people in one night at 4 separate residences. And how long the Wagners went without being arrested. I mean, they moved to Alaska and back during the course of this investigation. And just an update on Billy's trial. The earliest Billy Wagner will go to trial is January 6th, 2025. You look at how many family members were taken from these families within a matter of a couple of hours. I don't know how they do it. I think the jury absolutely got it right in this case. To me, the defense theory that George was totally oblivious, just not believable. All right, guys, that's it for today. Hope you guys have a good rest of your afternoon. We will see you soon.